At that point, I'm going to hand over to Elena and David from Charles Douglas Mayfair to talk about the immigration issues that will sort of interact with this subject. And there's a few questions coming in on the chat, so I'm going to have a read of those whilst Elena and David are talking, and we might pick those up at the end of their session. Thank you.
Good morning to those of you who are in the UK, and good afternoon to those in India. Thank you for the reason to put on a dress and makeup today. The immigration system has been particularly hard hit by the widespread disruption caused by COVID-19. In response to this pandemic, we have seen lockdown and travel bans imposed on a global scale. The impact of these measures on migrants' ability to enter, leave and remain lawfully in the UK is significant and growing. The lockdown has affected the way we work, travel, socialize and communicate with each other, changing family and business models and dynamics. It may feel like we're inhabiting a surreal alternate universe where every day is Groundhog Day. It feels like a lifetime ago that we began panic buying toilet paper, painting rainbows, baking cakes, and planning for the end of the world. But now that we're at the end of the lockdown in the UK, the future feels a lot brighter. It was only on the 23rd of March that the government imposed a nationwide lockdown in the UK, shutting all businesses, venues, and facilities, and banning all non-essential travel. By mid-April, it was estimated that unemployment could rise to 3.4 million and the GDP could fall by 35%. The governor of the Bank of England called on the British government to provide support to businesses affected by the virus to prevent British economy falling into a recession. The government responding by introducing a number of legislative measures and schemes to prop up businesses around the country. As Tim has already mentioned, on the 20th of March, the government announced the coronavirus job retention scheme. And since the 20th of April, a total of 6.3 million claims have been made, accounting for 23% of the employed workforce in the UK. On the 23rd of March, the government also introduced the coronavirus business interruption loan scheme for small and medium-sized businesses and corporate financing facility for large companies. This is something that Paul will be covering later today. However, these schemes are a far cry from being a miracle cure for most businesses. Where emergency measures have left a vacuum, service providers, including lawyers, such as ourselves, and accountants, such as Moore Kingston Smith, have stepped in to provide cogent practical advice to help businesses. The pandemic has created significant challenges for UK employees and employers, in particular those employing workers as a result of a slow response from the Home Office. Since the end of March this year, the Home Office has issued a series of piecemeal policies and concessions whose legal status remains very unclear, seeking to reassure sponsors and migrants. However, falling a step behind other government departments, the Home Office has failed to provide a clear and reliable roadmap. However, despite the uncertainty as we find our way out of the coronavirus lockdown, UK borders remain open, allowing sponsors to continue to rely on labour and plan for the future. During this webinar, David and I will examine the main issues currently facing UK businesses who hold Tier 2 licenses and who employ foreign workers. We'll discuss the Home Office's COVID-19 policy response and how this policy is applied to sponsors in practice. And we'll also discuss the wider human resource implications from the relevant issues and the Home Office policy response. A downturn in demand and revenue is something that many businesses have already suffered or are preparing to suffer in the UK. Many businesses have had to be quick on their feet to adapt their entire way of working in response to the pandemic. Most businesses have either had to cease trading, for example, those operating in the hospitality and food and beverage industry, or significantly adapt their ways of working, for example, by asking staff to work remotely, our entire team, for example, we are working remotely and have been for some time in order to safeguard the health and of the workforce and to observe the social distancing guidance. As salaries typically represent a large proportion of businesses' running costs, many employers are seeking to reduce their overheads by permanently or temporarily cutting their workforce or by changing their employers' terms of employment, including the numbers of hours worked or their rates of pay. The recruitment and retention of Tier 2 employees is also being duly affected. Sponsors are grappling with significant difficulties in adapting their sponsored workforce to the demands of the current situation, and in doing so, understanding what impact implementing any changes will have on their sponsored migrants' visas, or their ability to maintain compliance with their sponsor duties and on the wider human resource issues. Looking to the future, as we are now, this autumn, the government will launch a new UK immigration points-based system, even though we've already been operating under a points-based system since 2008. But this is a new one. The new arrangements will take effect on the 1st of January 2021, once the freedom of movement from the European Union ends. And the new system will treat EU and non-EU citizens equally. The points-based system is something that the government is very keen for the UK employers to be prepared for, because the new system, they say, will be employer-led, including a route for skilled workers who have a job offer from a UK approved sponsor with a minimum general salary threshold of £25,600, which is a reduction from the current levels. I will now hand you over to my colleague David, who will deal with the application of the coronavirus job retention scheme to businesses that employed Tier 2 migrants. Over to you.
Thanks, Elena. Good morning again if you're in the UK, and good afternoon if you're in India. I won't go into detail in regards to the retention scheme and the eligibility, as Tim has gone over this in detail. What I will say, and the question really from an immigration point of view, is whether Tier 2 sponsors and their migrant workers are actually eligible for the coronavirus job retention scheme. In short, the answer is yes. However, the Home Office's response to this has been slow, and there remains quite a few questions as to the operation of the scheme and how it reconciles with the Tier 2 sponsor framework. For example, the guidance released on the 27th of March by the Home Office was silent on whether Tier 2 sponsors could utilise the scheme for their sponsored employees. Further guidance was released on the 3rd of April, but again it was very limited, and it stated that you could temporarily, as you'll see there, you can temporarily reduce the pay of your sponsored employees to 80% of a salary, or £2,500 per month, whichever is the lower. But it didn't state explicitly that sponsors can use the scheme. I'll come on to that point later. But later that day, 3rd of April, the Immigration Law Practitioners Association, ILPA, clarified matters to the extent that Tier 2 sponsors and sponsored migrants are eligible for the scheme. There's been further Home Office guidance released, well, twice actually, on the 14th and 20th of April, but neither has sought to update the wording of the COVID-19 guidance for sponsors. So where does that leave us actually, and what issues should sponsors be aware of if using the scheme? Our first port of call here is the Tier 2 minimum salary requirement. And generally, Tier 2 migrants have to be paid a minimum annual salary in order to maintain the validity of their Tier 2 visa. You'll see there that the salary must meet this minimum threshold. This is under these figures are taken from the Immigration Rules Appendix J. And you'll see for a new entrant is 20,800 under the Tier 2 General, 30,000 for an experienced hire, or 41.5 for a Tier 2 intra-company transfer worker. However, there's a conflict here with that, with the figures put forward under the coronavirus retention scheme. As Tim said, a furloughed sponsored worker's salary will reduce to 80% or a maximum of £2,500 per month, whichever is the lower. This, you'll see, is actually lower than the minimum required salary for many Tier 2 workers. This being the case, what consequences are there for sponsors if they furlough sponsored employees and they pay less than the minimum salary? Again here, the Home Office COVID guidance, it's not clear in whether the minimum salary rule still applies to all or some of the Tier 2 workers. I mean, this is quite troubling for those employing Tier 2 workers. And given this uncertainty, sponsors actually may find that their sponsored migrant workers are unwilling to provide the written consent to being furloughed. And this, as Tim pointed out, this written consent is a precondition for sponsors seeking to apply to the scheme. So what is the fallback position in this instance? The Home Office, we'll look at the Home Office's Tier 2 guidance in this, and it's quite clear in that if a worker's salary drops below the required threshold, the sponsor's required to terminate the sponsorship of the employee and report this to the Home Office using the SMS, or the sponsor management system. This being the case, then the Tier 2 the Tier 2 employee would cease to be sponsored and they risk their visa being cancelled or curtailed. Looking at it on the other aspect, though, if a Tier 2 employee is not furloughed under the scheme, but instead asked to work reduced hours, then their salary can be reduced on a pro rata basis in accordance with the standard rules. But the salary, you need to bear in mind, must however not fall below the relevant Tier 2 visa category minimum. So what other issues are there that Tier 2 sponsors need to be aware of using the scheme? The Home Office's guidance, again, is not very clear, and you'll see that any reductions must be part of a company-wide policy to avoid redundancies in which all workers are treated the same. As Tim pointed out, from an employment point of view, it's important to note that all workers need to be treated the same in this respect. Sponsored workers, sponsored migrants cannot be treated differently. Otherwise, you could have discrimination issues that apply here. And again, the written consent from the sponsored worker is key here. So, as I touched on earlier, what does a Tier 2 sponsor need to prove or Willa Tier 2, sorry, a Willa Tier 2 sponsor need to prove a reduction in trading to apply to the scheme. Again, the guidance is not clear here, and there's no guidance in terms of the COVID-19 situation. And we're awaiting further guidance on it. The only possible insight on what may constitute a reduction in trading comes from the Home Office's current sponsor guidance, which provides examples of situation of a change in circumstances. This includes becoming insolvent, entering into a CVA or a debt arrangement scheme. But other than that, there is nothing in relation to COVID that the guidance sets out. In this respect, further guidance is needed from the Home Office to understand if a broader definition, which includes COVID-19 related issues, can be applied and utilised by businesses. I'll now hand you over to Elena again, and she'll discuss what, if any, duties sponsors have to notify and the teacher workers, particularly in terms of unpaid leave and the right to work checks during COVID-19. Elena.
Thank you, David. Tiers to sponsors, I think we take it as given that everybody attending this webinar is aware of the general and tier-specific duties that Tier 2 sponsors have, because Tier 2 licensed sponsors are subject to a number of duties and obligations, including reporting and record keeping. Sponsors must report certain information, including any significant change in the migrants' workers' employment circumstances, to the Home Office, using the sponsor management system within a certain prescribed period of time. This would include furloughing a sponsored worker and paying them a reduced salary. However, the existing COVID-19 guidance for sponsors that David has already gone over is again silent on whether the Home Office must be notified of this change. We as a team have been advising clients to adopt a cautious approach until this guidance is clarified somewhere down the line by the Home Office, and keep internal records. Again, if something is unclear because the guidance across the board is very general, and it's very difficult to see at times how it marries up with the guidance introduced by other government departments and agencies. If in doubt, it's very important to stay in touch with the sponsor licensing unit, with the business help desk, who have been very responsive, and also with the dedicated coronavirus immigration team, who have again been tremendous in all of this and clarifying various details. What we have found in practice is that the responses some of our colleagues and clients and we ourselves receive from the policy department within the Home Office often differ with what the COVID-19 guidance says. So be very careful in the way you apply it to your own company and your own situation. Now, as you know, sponsors must ordinarily report a number of issues to the Home Office within 10 working days, and they're listed here on the screen. I don't need to go through them, other than to say that, for example, absences of employees from the workplace due to coronavirus pandemic do not need to be reported to the Home Office, but be careful about reporting the change to the salary level to the one stated on your on the CIRS in any respected sponsored migrant. Again, working from home or working remotely, during this coronavirus lockdown does not count as a change of location for Tier 2 purposes. So you don't need to do anything about reporting it as a different location. Now we'll move on to dealing with unpaid leave. According to the current COVID-19 guidance, Tier 2 sponsors don't currently need to withdraw sponsorship from employees who are absent from the workplace without pay for 4 weeks or more, providing that the absence is related to the coronavirus pandemic, and absences related to coronavirus don't need to be reported to the Home Office. This can include absences due to illness, somebody contracted COVID-19, the employees need to isolate or shield, and their inability to travel to work due to the lockdown restrictions. The Home Office will not take any enforcement action against sponsors who continue to sponsor employees despite their absences due to coronavirus. However, again, we advise to keep internal records of the duration and reasons for any unpaid absence that extends beyond the 4-week period, and how this relates to the coronavirus pandemic in each individual case. Under the normal circumstances, Tier 2 workers are usually prevented from taking more than 4 weeks of unpaid leave each calendar year. The 4 weeks is worked out according to the migrant's normal working pattern. So where the sponsor is required to stop sponsoring a migrant who has been absent from work without pay for 4 weeks or more, the sponsor must report this using their normal SMS account. This applies whether the migrant is absent from work over a single period or for more than one period during any calendar year, counting from the 1st of January to the end of the year to the 31st of December. The only exceptions to this are whether unpaid leave is for statutory paternity, maternity, shared parental leave, adoption or sick leave, and assisting with the national, international, humanitarian crisis overseas, provided that you agree that absence for that purpose with your Tier 2 employer. Now, on the 30th of March this year, the Home Office was issued another guidance, which doesn't form part of the main COVID-19 guidance, and this is a discrete part of it, so you need to look for it, relating to the right to work checks. And the right to work checks, we know what the obligations are on Tier 2 sponsors. They've been temporarily adjusted due to the COVID-19 pandemic to make it easier for employers to carry them out. So the following temporary adjustments have been made. Employers can now carry out checks over video calls. You can arrange a video call with your existing or a prospective employee. You can ask them to hold up the original documents to the camera and check them against the digital copy of the documents and record the date, the check, and mark it as adjusted check undertaken on such and such date due to COVID-19. These are the wording, this is the wording which comes from the COVID-19 guidance. If the employer has a BIP or a BRC which is valid, or they have a status under the EU settlement scheme, the sponsor can also use the online right to work checking service while doing a video call, while they have the employee on the online. And the employee must give you permission to view their details online. Job applicants and existing workers can also send scanned documents or a photo document, a photo of that document for checks using email or a mobile app, rather than sending originals to the employer. In the alternative, employers should use the employee checking service if a prospective or existing employee cannot provide any of the accepted documents. If the person has a right to work, the service will send you a positive verification notice in the normal way, which provides you for a statutory excuse for 6 months. The right to work checks continue to be necessary, and employers must continue to check the prescribed documents listed in the right to work checks and employers guide, which is available online, which you probably all have. It remains an immigration offence to knowingly employ anyone who does not have a right to work in the UK, leading to civil and or criminal penalties. After the COVID-19 measures end and are lifted, employers should follow the checking process set out in the right to work checks. You will be asked to carry out retrospective existing employees who started working while these measures were in place. The retrospective checks must be carried out within 8 weeks of the COVID-19 measures being lifted. Both checks should be kept for your records, and you should mark on your systems, you should mark the COVID-19 checks, the adjusted checks, with the following wording, and the wording should be: the individual's contract commenced on a particular date, and the prescribed right to work check was undertaken on that date due to COVID-19. The Home Office guidance states that they will not take any enforcement action against the sponsor if you carried out the adjusted checks as prescribed in the COVID-19 guidance, or a check via the UKVI online system, and follow this up with retrospective checks. If at the point of carrying out retrospective checks you find your employee does not have permission to be in the UK or to work in the UK, the employer must end their employment. The guidance for this is, described in the right to work normal guidance. If the checks the sponsor has undertaken during the adjusted period were conducted in the prescribed manner, there is no need to undertake a retrospective check. However, if in doubt, again, check with the Home Office. I hope that you will find the topics we have covered today on the immigration side useful to you and applicable to your business. If you have any questions, we would be happy to answer them at the end. I will now pass you back to Tim. Thank you.
Thanks, Elena. So there's a lot of detail there. If I can just direct you also, if you can find your way to the CDS Mayfair website, there's a really good set of Q&As around immigration topics, particularly those relevant to COVID.